1 start. Ministerial work includes the work which is related to obedience to instructions or laws instead of discretion, judgment or skill. And ministerial duties include recording judgments on the docket. Stop. The judge may apply it to a particular state of facts. Stop. A ministerial act, on the other hand, may be defined to be one which a person performs in a given state of facts and in a prescribed manner or in obedience to the mandate of a legal authority. Stop. In ministerial duty, nothing is left to discretion because it is a simple and definite duty. Stop. Clearly, in the light of the above, now, it is clear that filing of a case in a registry does not give any adjudication and has to be treated as a ministerial function. Stop. The proviso does not permit hearing, giving decision to which the matter relates. Stop. This provides an examination of the limited area. Stop. Ministerial office is an office that does not include authority to exercise judgment, but only to carry out orders given by a superior office or to perform duties or acts required by rules, statutes or regulations. Stop. Ministerial act is an act performed without the independent exercise of discretion or judgment. Stop. If the act is mandatory, it is also termed as a ministerial duty. Stop. Ministerial duty is a duty that requires neither the exercise of official discretion nor judgment. Stop. Light is shed on the issue under consideration by the judicial pronouncement. Stop. This judgment was rendered prior to the framing of the circular and it may not strictly apply to the present case. Stop. However, the discussion and the principles laid down give guidance to this adjudication and deserve to be considered in detail. Stop. The transfer of the writ petition was sought on the ground that the militancy situation prevailing at Srinagar rendered it impossible for the respondents to contest the writ petition there. Stop. Learned counsel for the non-applicant has also placed reliance on the pronouncement of the judgment of the Honorable Supreme Court in the matter of Kamini Jaiswal versus Union of India. Stop. This application was opposed by the writ petitioner who contended that it was easy for him to contest the petition only at Srinagar. Stop. This petition was transferred by Honorable the Chief Justice along with connected applications and contempt petition. Stop. This order was challenged by the appellant on the judicial side, contending that there was no provision under the Constitution and therefore, the order of the court was bad in law. Stop. The challenge was repelled by the single bench. Stop. The appeal therefrom was placed before a division bench comprising of the then Chief Justice who rejected the same. Stop. The allotment of work includes work allotted to the judges sitting at various benches of the High Court concerned. Stop. The fact remains that the Chief Justice has been empowered to allot work to judges and to specify the cases which would be heard by them. Stop. Since the High Court is one court with two places of sitting and a High Court cannot be divided, therefore, there cannot be a transfer of case in the strict sense of the word. Stop. Nevertheless, Chief Justice can suo motu or on the application of a litigant decide as to which case would be heard by which judge and at what place of sitting. Stop. Since the Chief Justice has the administrative power apart from his powers on the judicial side and since he has to run a big institution, which is an ever-growing institution, he had to be conferred with wide powers as had been done under the Constitution of India, as also under the various provisions of the High Court. Wide amplitude has to be conceded to the Chief Justice, or else it would hamper the proper running of the institution, which would adversely affect the course of justice and the interest of litigants for whose benefit the courts have been created. This judgment, therefore, declares about the legal position that apart from the powers on the judicial side, the Chief Justice has wide administrative powers as conferred under the Constitution of India. It has also been specifically held that under Rule 8 of the High Court Rules, 1999, the Chief Justice has the power to allot work to the judges, and that allotment would include shifting of a case from one bench to another. Judges shall sit alone or in such division courts as may be constituted from time to time and do such work as may be allotted to them by order of the Chief Justice or in accordance with his direction, and they shall be constituted from time to time and do such work. A careful reading of the aforesaid provisions shows that the administrative control of the High Court vests in the Chief Justice of the High Court alone, and that it is his prerogative to distribute business of the High Court related to both judicial and administrative works. He alone has the right and power to decide how the benches of the High Court are to be constituted, as well as which judge is to sit alone and which cases he can and is required to hear, as also as to which judges shall constitute a division bench and what work those benches shall do. In other words, the judges of the High Court can sit alone or in division benches and do such work only as may be allotted to them by an order of or in accordance with the directions of the Chief Justice. The power to make roster exclusively vests in the Chief Justice, and that a daily cause list is to be prepared under the directions of the Chief Justice, as is borne out from Rule 73. However, the instant case is not concerned with assignment of rosters by the Chief Justice, but with the working of Circular Number 6. Given the above discussion, so far as the present consideration is concerned, this judgment is concerned with roster allocation, and it would have no application in the present case. The first issue would not detain us because it is no more res integra. Ministerial duty is a kind of duty which requires no element of discretion or independent judgment. Recently, this court dealt with the nature of distinction between judicial or ministerial functions. The judicial function entrusted to a judge is different from an administrative or ministerial function which can be delegated or whose performance may be done by giving the authority to do it. The judicial function consists of the interpretation of the law and its application by rule or discretion to the facts of particular cases. The organs which the state sets up to exercise the judicial function are called courts. If a judge dealing with a particular matter has to exercise his discretion in arriving at a decision, comma, he is acting judicially, and if on the other hand, comma, he is merely required to do a particular act and is precluded from entering into the merits of the matter, comma, he is said to be acting ministerially. Stop. Judicial function is exercised under legal authority so as to decide on the disputes, and it is done after hearing the parties, and the decision affects the rights and obligations of the parties. Stop. There is a duty to act judicially. Stop. स्टॉप को मिला के 124 पे